With panel 3. Thank you for braving up Friday afternoon with lovely weather after lunch. I assure you that we're full of action and excitement with our third panel. I will turn the time over to our moderator, the Honorable Judge Stephen Williams, who's a judge on the D.C. Circuit Court of Appeals, and he'll introduce the panelists and get things going.
I think I'm going first.
The structure of the panel is this. At first place, it moves very simply from my left to the right. We start with Clay and Anna, Mike. And it's going to be municipal experience. And there's going to be sovereign experience, that is to say, real sovereigns. And then there is Professor McConnell, who will, bearing those in mind, apply the Constitution to our own subject states themselves. Clay.
Thanks, Stephen, and thanks, Peter, for organizing this delightful conference. I'm going to summarize some aspects of municipal insolvency law, concentrating on Chapter 9 and alternatives, and time permitting, which it won't, apply some of those principles to state insolvency. The procedures I'm going to discuss follow from the principle that a municipality in fiscal distress is not susceptible to the same creditor remedies as a private corporation. Creditors of municipalities generally cannot, as we've heard, seize the fiscal assets of a municipality. They cannot execute on the courthouse or the fire engines of a municipality in default. It's plausible that a municipality will be subject to a mandamus action to increase taxes or reduce services in order to pay creditors. George Triantis has already reminded us that in the 1970s, in the New York City fiscal crisis, the New York Court of Appeals insisted that a legislatively enacted moratorium on payment of city debt was invalid because the state constitution mandated that municipal debts be paid even if tax limits had to be exceeded. But the late 19th century and Depression experience with mandamus actions or efforts to garnish municipal funds gave little solace to creditors, and it remains unclear whether other state courts would, as New York did, demand municipal tax increases, especially in the absence of analogous constitutional mandates, analogous to what was found in New York State, or whether any such orders would indeed generate net tax revenues. Most of the law dealing with municipal insolvency, therefore, deals with the adjustment of existing obligations. Chapter 9 permits municipalities to file for bankruptcy, although any such filing must be voluntary with the municipality. The filing of such a petition would stay any creditor actions against the municipality regardless of their practical utility or disutility. But before you make too much of that, note the following, some of which our previous speakers have already stated. First, a bankruptcy has limited meaning here. It does not mean liquidation of the municipality. Essentially, it means that there's a system for the adjustment of debts, the rejection of onerous contracts, and the ability to borrow additional capital. Second, the capacity of municipal corporations to take advantage of bankruptcy is constrained. In order to enter Chapter 9, a municipality must be specifically authorized to do so by the state of which it's a political subdivision. The standard explanation for this requirement is that it's constitutionally required in order to avoid federal interference with the state prerogative. If time permits or in discussion, I'll question that actually. Next, to enter Chapter 9, a municipality must be, well, a municipality. That actually has some implications for state bankruptcy because one of the issues that would have to be faced in a state bankruptcy is who is the state? The Bankruptcy Act defines a municipality as a political subdivision or public agency or instrumentality of a state, and this would presumably include both general purpose municipalities, but also some state authorities that are actually more closely associated with the state itself than with any particular municipality or municipal corporation. Finally, in order to enter bankruptcy, a municipality must be insolvent. For Chapter 9 purposes, insolvency requires that a municipality be unable currently or prospectively to pay its bills as they become due. Unfortunately, this test raises a variety of questions that are not easily answered. The first test, that is involving current non-payment of debts, seems relatively straightforward. But the second prospective test looks to future capacity to pay. And this necessarily raises issues of how prospective is prospective and what steps a municipality must take in order to avoid non-payment before it can be considered insolvent. If a municipality, for instance, has access to funds that it has not fully exploited, to what extent does it fail the prospective test? And who, to go back to Judge Williams' question at the end of the last session, who is to determine whether efforts to obtain funds will generate net revenues or force payers to exit the locality? Now, that inquiry is a nice segue into the next point I want to mention, the role of courts in municipal bankruptcy. As a doctrinal matter, Chapter 9 includes a statutory ban on judicial interference with the political or governmental powers of the debtor municipality, any of its property or revenues, or its use or enjoyment of any income-producing properties. Many commentators also suggest this is constitutionally required. Nevertheless, there are serious practical limitations to this non-intervention principle. Courts retain substantial discretion in determining whether the locality has cleared a variety of vague hurdles necessary to obtain relief under Chapter 9. For instance, return to the insolvency requirement. A judicial determination that a municipality fails the prospective insolvency test because it has room to increase taxes or cut services may be the functional equivalent of a judicially imposed tax increase. Similarly, the court must accept the plan that the municipality proposes in order to exit bankruptcy. A court obviously retains substantial discretion to make that acceptance contingent on the inclusion of tax increases or service cuts. The result is that, notwithstanding federal limitations on judicial authority, courts have the capacity in bankruptcy to do indirectly what they could not do directly. Finally, let me mention some of the consequences of bankruptcy. Of course, the big issue these days, is whether municipalities in Chapter 9 can reject executory collective bargaining agreements. Although Congress enacted a provision of the Bankruptcy Code that limited the general ability of debtors to reject collective bargaining agreements, Congress did not include that provision within those sections of the Bankruptcy Code incorporated into Chapter 9. Congress did, however, include the relatively expansive capacity to reject contracts, which the Supreme Court has interpreted to include collective bargaining agreements. Some lower courts, including the recent decision flowing from the Vallejo, California bankruptcy, have interpreted the Bankruptcy Act to permit rejection of collective bargaining agreements in at least some circumstances. But those decisions remain controversial in the absence of some authoritative statement from either Congress or the Supreme Court. Now, note that notwithstanding its availability, we've already heard from Adam about how Chapter 9 is rarely used. Indeed, only about half the states have even enacted the statutes necessary for a municipality, for one of its municipalities, to file a Chapter 9 petition. The Chapter 9 process is time-consuming and expensive. It tends, therefore, to be used by single-purpose municipalities, such as irrigation districts or small localities, rather than, say, Detroit. General-purpose municipalities that have used bankruptcy tend to have done so because of one-off events, such as a large lawsuit that exposes them to fiscal distress, rather than because of systemic fiscal difficulties. But even for distressed municipalities that do not enter Chapter 9, the availability of bankruptcy can play a strategic function. To understand why I say that, consider the alternative strategies that are used to assist fiscally distressed municipalities. Typically, those strategies involve some form of state intervention. State constitutional law generally permits state legislatures to abolish or alter the governance structures of their political subdivisions. So states can essentially place localities into receivership, eliminate democratically elected governments, and replace them with appointed oversight boards or fiscal control boards that have substantial authority over budgeting, expenditure, and revenue-raising authority. In the past few decades, we've seen financial control boards displace substantial functions of elected local governments in New York, Cleveland, Nassau County, Benton Harbor, Michigan, Chelsea, Massachusetts, the Chicago School Board, Pittsburgh, and Philadelphia. State efforts along these lines vary from those that require oversight vary a bit from provisions that perhaps just allow advisory authority to those that allow financial control boards to write the budgets for the municipality. Perhaps most importantly, boards can generally restructure outstanding debt by a combination of negotiation, read arm twisting, and issuance of new debt, usually secured by dedicated revenues, often with longer duration periods than the debt that it displaces. In theory, then, boards provide a centralized decision-making entity that is less susceptible than elected officials to the kinds of interest group bargains that many say are responsible for the fiscal distress in the first instance. Now, I want to make just a couple of points about these efforts. First, when states act to displace local government officials, they typically do so less to assist the distressed locality as a locality than to avoid the risk or perception of contagion to other localities or to the state itself. And this raises an interesting question about the identity of the true constituents of the Oversight Board. Do they represent residents of the municipality, creditors, or the state itself? Second, the need to assist its localities places a substantial burden on the state itself and thus exacerbates state financial difficulties. What this means, of course, is that states that bail out municipalities tend to address the moral hazard problem by imposing harsh conditions, including the removal of authority from elected officials. Municipal officials, of course, would prefer bailouts with weak conditions. Much of the recent history of municipal bankruptcy entails efforts by the municipality to extract weak conditions for bailout by threatening to declare bankruptcy, which would impose even greater harms on the centralized government as a result of contagion. As a result, even if we don't see lots of municipal bankruptcies, the background ability of a municipality to enter bankruptcy may reduce the capacity of the state to address the moral hazard problem. So let me conclude just by suggesting that that same strategic issue could come into play in relationship between states and the federal government, whereby the states, if they had the right to declare bankruptcy, might be able to use that right strategically to obtain a weaker conditions of bailout from the federal government than would otherwise obtain. And perhaps what we should be thinking about, which I'll be happy to talk about in Q&A, is the possibility and indeed constitutionality of something like financial control boards at the federal level with respect to states, the same way the states utilize them with respect to their political subdivisions. Many thanks.
So first of all, thank you so much for having me. It is incredibly humbling to be here, partly because the very people on this panel are the people whose work I read when I was moving from kind of restructuring and bailouts to actually writing about restructuring and bailouts. So it's, and particularly gratifying is the title of this conference, which is actually, I think, a riff on Professor McConnell's 1993 article, which is probably the very first thing I read as I was moving from the Treasury into the academia. So this is totally meaningful for me. So my remit is to talk about the international dimension, and I always start any general introduction to sovereign debt, which I think with my favorite law quote about sovereign debt, which comes from Learned Hand. It was his letter to Harlan Fiske Stone, commending Stone on his concurrence in Perry versus United States, a case where the U.S. Supreme Court reprimanded the U.S. government for stripping gold clauses out of its debt. It also did it out of private debt, but the U.S. government debt was about a little more than 1/5 of the total. But then, much like the case George described, said that the creditors could not collect damages. And Learned Hand sort of thought that this was pretty tortured, and he basically said, look, everyone dealing with sovereigns knows he's dealing with a creature who can Welsh if he wants to Welsh. To trick up a lot of international stuff as if it were law, frankly, makes me puke, as dear old Oliver Holmes used to say. And I take that as my continuing motto. But it actually sort of seriously points out that national governments have long occupied this gray space between law and sovereignty, And they've done that really since before there were national governments. I mean, Greek city-states too. And I'm not sure, therefore, to what extent this experience translates to sub-sovereigns or other bankruptcy settings. So in my 10 minutes, I want to talk first, as Peter told me, I want to describe the world of sovereign debt. Second, I would like to highlight the basic strands of sovereign debt theory and sketch out the landscape of sovereign debt restructuring institutions, including some salient proposals of the past decade or so. And if we have time, we can talk about Greece. If we don't have time, we can surely talk about Greece during the Q&A. So sovereign debt. It makes sense to talk about two distinct categories of sovereign debt. It is true that there's about, just under 40 trillion of this stuff out there. But really, there are two different pots. One is domestic sovereign debt securities, and this is the dominant category. It's local currency, local law debt, which is especially predominant among rich countries, read US, Japan, Europe. Even though this is the category of debt where the debtor has a lot more flexibility to devalue and restructure by fiat. By contrast, most of the theory has focused on a subset of international sovereign debt securities. So foreign currency, foreign law debt, usually of developing countries. And this is just a sort of an illustration putting the two together, since I couldn't do two different sized circles. Most of the theory and the policy is about the teeny little purple sliver. The international sovereign debt of developing countries drives the theory. Most of the debt out there is domestic, local law, local currency debt of rich countries. And I think that's worth thinking about. Now, one of the things this sort of bears to stress here is that sovereign countries are different from states in several important respects highlighted here. First, they issue currency. Big exception, common currency zones like the EU and countries that have adopted other people's currencies like Ecuador, which is dollarized. But sub-sovereign states do not, especially if you don't count scrip. The other important thing that this sort of breakdown brings out is that sovereign countries enact laws, they have courts, and they regulate financial institutions, thank you, to which they can whom they can encourage to pick up some of the government debt, and they do. Sub-sovereign states do not do that to the same extent. They're really hybrids, as people described. So central governments have different legal, political, economic debt management tools, and there are different externalities from their default. It's important that different countries are very, very different. This is Japan. Most of its domestic debt is held by domestic regulated institutions. Therefore, nobody really cares about the S&P downgrade of Japan. The bulk of its creditors are at home and do as they're told. Now, three things are missing in the slides. Debt such as bank loans and supplier credits. Now, bank loans were big in the 70s and then kind of got replaced by bonds. Supplier credits were big in countries like Iraq. Debt to official creditors, other governments, multilaterals such as the IMF and the World Bank, can be enormous in poor countries, Liberia, Nigeria. And domestic liabilities not expressed as private market claims, teacher pensions, et cetera, that is not in any of the pictures and not in any of the theories, and this is very important when it comes to talking about debt restructuring. So a very brief moment on theories of sovereign debt. They really took off in the 1980s when Mexico and others suspended payments on bank debt. Everything keys off this idea of sovereign immunity, immunity from lawsuits and immunity of assets from attachment. As a practical matter, immunity of lawsuits has really, really weakened. It's, you can sue Argentina by copying somebody else's complaint in roughly 2 minutes. The problem still remains enforcing your judgment, right, and finding assets outside the country that are not immune from attachment. Here, I think it's also important to note that the immunity of foreign sovereigns and U.S. states is quite different, except I don't know the first thing about the immunity of U.S. states, except that it's quite different. But I think in drawing the analogy, I think it's very important to point that out. Now, the dominant preoccupation of the theory is, so given that sovereigns are immune, why do they pay and why does anybody lend to them? And there's the reputation theory and the enforcement theory. I think it's fair to say the two have come to a draw. The other sort of theoretical preoccupation is what are the grounds for sovereign debt restructuring? And here there's the debate about ability and willingness to pay. In a way, this brings together the conversation about immunity and the conversation about debt overhang, which was discussed already. Now, the interesting thing about this is that in foreign sovereigns, the distinction between ability and willingness to pay is really murky, right? Because your taxing capacity is part of your ability to pay, but of course that is profoundly political, and therefore is it ability, is it willingness, or is it really a wash? Now another important thing about this is that US states, unlike foreign governments, do issue debt of different constitutional priority, thank you, and issue effectively secured debt in the form of revenue bonds. Foreign sovereigns just don't do that at all, right? Now, saying that there is a murk around ability and willingness to pay is not the same as saying it's all political, therefore let's walk away. There still remains the question of how do you restructure the debt? And this brings us to the proliferation of restructuring institutions in the world of sovereign debt, right? So countries default with a huge amount, all the time. So Rogoff and Reinhardt, had a paper before they had their famous book called Debt Intolerance, where they basically say that, a lot of the repeat defaulters spend like a quarter of their time in default over 200 years, right? So how is this debt distress dealt with? Well, in a very disjointed and kind of fragmented way, right? The big link is, and really the operational restructuring, if you will, comes via the IMF program, but it all operates as cross-conditionality. So foreign governments restructure their debt to other governments in the Paris Club, private commercial banks in the London Club, bondholders in these sort of non-system exchange offers, right? They're not formally linked in any way. And this is the huge distinction between sovereign debt restructuring and bankruptcy. Bankruptcy is a comprehensive, collective, ultimately judicial process. Sovereign debt restructuring is incredibly fragmented and informal. It really is the opposite, right? And the quasi-receivership that you get under an IMF program is enforced and implemented in a very non-transparent sort of web of conditionalities. So I want to wrap up with the debate about collective action clauses and the sovereign debt restructuring mechanism proposed by the IMF in 2002. This was a response, even though sovereign bankruptcy has been on the table in one way or another since Adam Smith, proposals have really blossomed since the mid-'80s and sort of came to their inflection in 2002. And this was very much driven by bankruptcy theory. This was all about fixing the collective action problem. Do we do it by contract or do we do it by bankruptcy? The important thing about this is that all the proposals addressed one half of that one little purple sliver, right? So foreign debt of developing countries governed by New York law, because those are the only ones that didn't have collective action clauses, right? So to talk about the sort of 2002-2003 episode as some kind of an epic bankruptcy moment, I think is highly misleading, right? It was basically a marginal exercise that has, I think, limited applicability to the rest of the world. Meanwhile, and this is going to be my last slide, we don't have time to talk about Greece, but meanwhile, while we're talking about this, right, lots and lots of sovereigns are restructuring their debt without using collective action clauses even when they have collective action clauses, as did Ukraine and Pakistan. And Ecuador didn't have collective action clauses and, restructured away and returned to the markets. The only time, so collective action clauses were broadly adopted in 2003 in all new issuances. The only time they were really used was in Belize in 2007. Whether that is somehow, again, sort of, a shining beacon to follow, I think we don't have enough evidence to say.
Thank you. Michael?
So I'm going to return to a question that David Skeel raised early this morning. Many people have alluded to it during the day, namely, would it be constitutional to extend some kind of a federal bankruptcy program to state governments? Could be done, for example, by extending Chapter 9 to the states or by some other comparable action. And I just wanted to talk about the constitutional issues. I want to emphasize here that I'm a bit torn myself on the policy. So I can see some advantages and some disadvantages, and I don't think that what I'm about to say is driven by any particular preferences for or against. Often when constitutional lawyers stand up and talk to you, you need to look at your wallet because the constitutional arguments so often are just in service of conclusions that they may have had on other grounds. But I think I'm innocent of that here. David this morning said that he believed that the constitutional question was relatively simple because even if states do have sovereign immunities of a sort from this kind of a process, that any federal bankruptcy law would be voluntary, and of course the state should be able to waive this just as they're able to waive sovereign immunity in every other context. And I want you to know that might be right. That might well be right. I want to talk a little bit about that, but I'm not here to say that that's off the table. But I do think it's more complicated than that, and it's also possible that it isn't right. Back when Chapter 9 was upheld by the United States Supreme Court, that is the Municipal Bankruptcy Code. This was United States versus Beacons. The first time, by the way, around, first time Congress passed a municipal bankruptcy code, the Supreme Court promptly struck it down on the basis that it was an unconstitutional interference with protected local government, and especially the sovereign authority of the states. Congress then almost immediately passed a new statute. I think they changed two words. That's an exaggeration. They made seemingly inconsequential changes to the statute and then ran it by the Supreme Court a second time, and the second time it did become constitutional. And there are essentially three rationales for the constitutionality of Chapter 9, and I want to talk about whether those might apply differently to state governments. The first obviously applies differently, and that is that city governments are traditionally, municipalities are traditionally not understood as sovereign entities. Under what now seems to us, I think, is rather archaic common law understandings, cities were corporations. They were municipal corporations formed by their residents for particular purposes that are somewhere between public and private. They were not understood to be governments in any formal sense of the term. And that's why, for example, 11th Amendment sovereign immunity does not apply to cities. You can sue cities. That's why, for example, our Civil Rights Law, Section 1983, allows suits against cities, but you could not have similar suits against states. At the same time, though, cities are regarded as governments for important purposes. They occupy a kind of no man's land. They're not purely private, and so in many areas of constitutional law, they are classified as governments. So, for example, a very famous federalism case, National League of Cities versus Ussery, was about cities, not surprisingly, and the court regarded cities as being invested with the same kinds of constitutional status as governments. And by the way, I think it's quite interesting to note, this was Congress's leading theory in the passage of the second municipal bankruptcy law, and Congress excluded from the coverage of the act counties, because counties and cities were originally understood as quite different. Counties were part of the state and were understood to be sovereign. Cities were municipal corporations, not sovereign. And the original, or the second Municipal Bankruptcy Act did not cover counties because Congress thought that it could not constitutionally do so. Some years after that initial act and after Beacons, the statute was amended to include counties as well. But if this is the ground on which the statute is upheld, that is that municipal governments are not sovereigns, well, states are for purposes of federal constitutional law, and that would simply mean we cannot do it, that there's no, you can't extend the same kinds of principles or treatment of cities to states. So if that is the ground, then state bankruptcy, extension of bankruptcy to states would be unconstitutional. There are, however, two other theories. The second, and this occupied the largest part of the federal government's brief in support of the statute in United States versus Beacons, and occupies a great deal of the Supreme Court's opinion in Beacons, is that the statute, the federal bankruptcy program, does not, in fact, interfere with the sovereign authorities of the jurisdictions to which it applies. Why not? Because unlike ordinary bankruptcy in the private context, municipal bankruptcy is completely voluntary. And in addition to that, under the original act, the federal bankruptcy court was not entitled to create its own plan. All it could do was either approve or disapprove of a plan that was drawn up by the city itself and presented to the court. In a sense, the feeling you get from reading the description of municipal bankruptcy in these 1930s era documents is that the court is really not interfering with the city at all. It is empowering the city to do something that the city wants to do for the city's own reasons and with full permission of the state. What's really going on here, I think, is that the federal government is lending to the states and the cities its power to authorize impairment of contracts. Because under the Constitution, the federal government has the authority to impair contracts, state governments do not, and effectively what this did was bless state and local impairments of contract. If this is the theory, then extension of the bankruptcy laws to the state should be constitutional, because it will also be true that the Bankruptcy Code is voluntary and that it does not empower the bankruptcy court to interfere in any way with the sovereign or governmental activities of the states, but only allows them to do something that they want to do for their own reasons. Problem with the second theory is that it's really not true. It's a quite unrealistic way of thinking about the statute. Clay Gillette explained this in his talk, because just because the bankruptcy court does not have formal authority to write its own plan does not mean that it does not have the ability to attach conditions, that it will refuse to accept a plan presented to it by the state unless the state has satisfied it with respect to certain things. And in particular, within the statute, there are two points at which state sovereign interests are surely going to be affected. The first is the requirement that the jurisdiction be insolvent. Well, as Clay explained, you can't tell whether the city or now the state satisfies this future inability to pay debts as they become due and owing standard without asking yourself the question, at what tax rate are we talking about, and with respect to what other claims and expenses of the city or state. And if the court is not satisfied that that the state has exhausted its other sources, either of additional revenue or additional cuts in spending, presumably the court is going to find that the entity is not insolvent, and that will effectively give the court power over some of the most important and fundamental sovereign activities of the jurisdiction. And I might emphasize here that the power of taxation is as much at the core of sovereignty as anything could possibly be. We fought the American Revolution over the proposition of no taxation without representation. That was a core principle of British constitutional law even before the American Revolution. I don't think that that is something that could be classified as anything other than a core sovereign right. So in addition to the insolvency standard, there's also the best interest of the creditors standard, which in private bankruptcy means that the creditors will be better off under the plan than they would be in the case of liquidation. But as several speakers have pointed out, we're not going to liquidate states or cities. We're not going to sell off their assets. We're not going to put them out of business. Instead, the legislative history of the Second Act indicates that this particular standard would be defined according to two prior decisions, both of them having to do with the concept that the city had not exhausted its taxing capacity. So I don't think there's much doubt that, in fact, contrary to the impression you might get from Beacon's and from the federal government's brief in that case, I don't think there's much doubt that that federal bankruptcy law would, in fact, cut very deeply into the sovereign powers of the state. So I'm inclined to think that that argument will not carry the day. The third argument is David Skeel's argument, that the state can simply consent, and there's a lot of support for that, and there are a lot of analogies one might invoke, of which waiver of sovereign immunity is certainly one, but it's by no means clear, because this really goes to a fundamental question of what is federalism for? What is the autonomy of state governments for? If we view this as a kind of states' rights, which I view as a quite misleading bit of terminology for federalism, which makes it look as though the state is something that has rights in and of its own name, well, an entity that has rights ought to be able to waive those rights, and so maybe consent is enough. But what if you think federalism isn't a matter of states' rights? What you think is that the division of power between the federal and the state governments has purposes of diffusing power and thus guaranteeing a kind of diversity and a check against tyranny and oppressive centralized authority. In that case, we are no more, the state should not be able to waive this. This is an essential structural aspect of federal constitutionalism and can't be waived. And my time is almost up, but I will invoke in support of this the United States Supreme Court decision in United States versus New York versus United States. I don't cite this to answer the question, but just to show that there is substantial ground and precedent for a view contrary to David Skeel's, in which this is a case about the Low-Level Radioactive Waste Act, which imposed certain mandates on state governments that the that the court concluded were beyond the powers of Congress, and the Supreme Court considered the question within that opinion, well, what about the fact that the state of New York and other states actually supported this legislation? Did they not give consent to this? How can we possibly say that it's unconstitutional as a violation of federalism when this is what the state wanted? And the Supreme Court's response to this is to say, and I'm quoting, state officials cannot consent to the enlargement of the powers of Congress be those beyond those enumerated in the Constitution, that the Constitution does not protect the sovereignty of the states for the benefit of the states or state governments as abstract political entities. State sovereignty is not an end in itself. Federalism secures to citizens the liberties that derive from the diffusion of sovereign power. If that logic were applied to federal bankruptcy extension to state governments, I think it suggests that perhaps the extension would be in trouble. Thank you.
Thank you. We'll have good solid time for questions. I have one small question I'd like to start with when people compose in their minds their more global questions, and that is for you. I've often thought about the origins of the United States in the principle of taxation without representation, the whole underlying scheme of things. But then you run into that Supreme Court decision upholding the order of a district judge to, is it Kansas or
Yes.
its particular school district?
It's Kansas City, Missouri.
Kansas
right.
City, to raise,
Missouri against Jenkins.
to raise its taxes by an amount, I guess, decided by the district judge in his infinite wisdom.
I can remember at the time being quite surprised by that. I thought it was, I don't think that was correctly decided. It's never been repeated. It's a one-off decision. And to the extent that you can excuse it, there were some complicated procedural aspects of the case that I think made the court, enabled the court to say that it didn't have to face the sort of, full-on implications of that. So I would not take that one to the bank.
Yeah, all right. Finding out a lot of things that can't be taken to the bank in this discussion.
Can I ask my, so I'm taken with this notion that perhaps states have some integrity and some, there's certain powers they have they cannot give away. There's some structural integrity that they have to retain. And I was thinking of that actually even before you spoke when Adam suggested the possibility of a state compact in which a state agreed that the governors of some other state could actually do, and I was thinking, well, wait a minute, that sounds like delegating away the powers of a state in ways that raise an anti-delegation doctrine that is alive and well far more in state constitutional law than it is in federal constitutional law. But in the bankruptcy setting, it seems to me that what the state would be consenting to is a procedure that strengthens the state. The state would be saying, look, we can't do what we're supposed to do. We're insolvent. And we need some sort of mechanism by which to regain the financial integrity that allows us to implement the structural functions that I would agree with you are emblematic of federalism. So if the state is not trying to surrender power or allow someone else to tell the state what to do, but rather is trying to employ the assistance of the federal government or a bankruptcy court in order to assist the state in regaining its capacity to fulfill its structural role, wouldn't that make a difference? Or would that make a difference?
Well, I think it would, and again, I'm not saying, I think it's a hard question, but much for me depends on how important the points where you were making earlier about how the bankruptcy court will inevitably have enormous power over core governmental decisions like what to tax, who to tax, how much, and what to spend spend their money for. And can I offer just one other analogy? I didn't have time for this. I do a lot of church and state law, but this reminds me a great deal of what is called the Entanglement Doctrine under the Establishment Clause. So one reason why governmental aid to churches is regarded as unconstitutional, it isn't just to protect taxpayers from having to support something they don't agree with, but it's because it's in order to protect against the kind of governmental interference and control of the religious institution that that the First Amendment is so much about. That the First Amendment is really more about protecting the autonomy of religion than it is protecting anything else. And so, and even though a church might want to get the money, a church school may even go out of business if it can't get some kind of governmental support. That was the record in a number of cases. Even so, they were not allowed to consent to these interferences with their own operations because it is so, because it isn't just their right, right? It has to do with what kind of a republic we are, that we are a place where religion is independent of government. And I don't mean to say that this is a direct precedent for federal bankruptcy law, but it is an analogy that another thing we are as a republic is one in which the state governments get to decide for themselves such things as what is going to be taxation and what are we going to spend money on.
I'm actually, just as a point of information, very curious about the scope of immunity for states in particular. Because I had seen in some very casual research cases that look very different from foreign sovereign immunity. So for example, foreign sovereigns are not immune in connection with just plain old market borrowing. It's clearly a commercial activity, whereas I think there is some play with states borrowing in the market, and I don't know how much play there is or what the distinction is, and I would love to know more about that.
Well, there is, running around the cases, a distinction between governmental and proprietary duties, and when you have, or operations, and when you have a proprietary, that is an economic entity that is separately made a separate agency. So if, for example, at a state park, you have a lodge, and it's a separate economic entity, and somebody slips and falls, they are going to be able to sue that entity, even though the entity is 100% owned by the state, because of this idea that there's some state functions that are purely proprietary and separately organized. But if you're going, if the suit has to do with governmental functions, and if it is the direct treasury of the state that is going to be tapped to pay, then the immunity exists.
So general obligation bond, is that an immune public activity, or is that
Well, you have probably the nation's greatest expert sitting on your left.
Hardly. In fact, I called, thinking I might be put on the spot in this way, I actually called somebody I consider to be a very well-qualified bond counsel a couple weeks ago and said, do states waive their sovereign immunity when they issue general obligations debt? And his response was, I think so. So my current, let's see, this will be my response for the next 10 minutes. It goes, I think, to the distinction you were making between a waiver of immunity to be sued and a waiver for purposes of execution.
May I just say, though, I think, I'm pretty sure that in order to sue the state on a general obligation bond, there must be a waiver of sovereign immunity.
Yeah,
and there are cases,
I'm confident.
I think there are like 20 cases in the Supreme Court in the 19th century about this.
I'm confident that is the case. So what I was about to say is...
Whereas in the international context, there need not be an explicit waiver of sovereign immunity.
What states do is when they pledge their faith and credit, that will be interpreted as the waiver of immunity. Now, you can sue the state Now try to collect. You go to the state treasurer, wholly apart from the tricks about mandamus, as Mike said a moment ago, if there is the quintessential 11th Amendment case is where you try to collect funds from the state treasury. And the answer is no, you can't do it, I think, again, without, and I see no explicit waiver against execution of a judgment.
Okay.
So it is not at all clear to me. And now keep in mind, in the 19th century, we had lots of repudiation of debts, primarily by southern states. And of course, and the 11th Amendment itself arose out of Chisholm versus Georgia and efforts to collect a judgment against the state of Georgia, in response to which Georgia passed a statute imposing a death penalty on anyone who tried to execute a judgment against Georgia. Those repudiations all gave rise to actions against the state. Nothing ever got collected on that basis.
Which actually could be, if bankruptcy law were extended to a state, this could be one of the practical consequences, because it is an unresolved question of law whether those full faith and credit provisions of state constitutions make it unconstitutional for cities or states to impair their obligations even within bankruptcy. But if federal bankruptcy law applies, it would preempt those provisions and enable states to dispense with provisions of their own state constitutions that would otherwise stand in the way of bankruptcy.
And just as an amendment to glom onto that, when George speaks about the Flushing National Bank case in which the New York Court of Appeals invalidates the state moratorium on New York City debt, the New York Court of Appeals is very careful to decide that case as a matter of New York State constitutional law. That is not a case that says that the New York State had or had not impaired. It never gets to the question about whether there was an impairment of the obligation of contract under the federal Constitution. It's simply as a matter of state constitutional law. Also, keep in mind that the prohibition is on impairment of the obligation of contract. You can repudiate a contract. You can breach a contract as a state without any. I'm looking at Mike to. I'm hoping I'm right in what I'm about to say. You can breach a contract or repudiate a contract and not commit a constitutional violation. An impairment of the obligation of contract it goes to the security that the creditor has for receiving ultimate payment. And when a state simply says, we're not paying you, that's not an impairment of the obligation of contract. Is that right, Mike?
Oh, well, if there's a breach of contract, that the state can breach but is required to pay.
Yes. Right.
But the sovereign immunity prevents the suit, so this is actually one of those cases where there's a right without a remedy.
Okay. All right.
And not so for a city.
Okay,
Thank
question.
you, Your Honor, for shepherding the discussion. So I'm hearing about these, especially from Michael's comments, sort of unpermissible delegations that fracture the Federalist scheme constitutionally. And I want to pose this problem. The Government Finance Officers Association, GFOA, get together. They're the CFOs of the states, basically. And they all agree with the municipal bond community to adopt a set of accounting standards that are promoted by the GASB, Government Accounting Standards Board. And one of the proposed standards for many years has been a government performance standard. I think it's statement 38. So now you have the CFOs of the states getting together, whether de facto or de jure, and delegating to a nonprofit. GASB is really literally on the other side of the hallway of a Connecticut office building from the FASB. deciding how to rank well-performing states and, by implication, their subdivisions. That creates the municipal bond market of the United States. What if the constitutional framers were in the room today to ask them, could they have imagined that the liquidity and credit quality of the states would be determined by an office building off the highway in Connecticut? What do you think they'd say?
They'd say, what is a highway? So I'm not sure that I understand the scheme, but if I get it correctly, any one state would be permitted to adopt those standards as a matter of the positive law of itself. And so what has happened is that all 50 states have gotten together and assured one another
With their bankers.
and they've assured one another that they will all, each individually, adopt those standards as a matter of individual state law. But if one of them backed out of the deal, I don't think the other states would have a legal right to force the others back in. It would just that they would suffer a market penalty if they did, as in no one would buy their bonds.
But coming back to your Chapter 9 discussion, what if the GASB creates a government performance standard, a standard for well-performing governments, in effect? So you have the taxpayers, the voters over here, but then there's the GASB's performance standard right here that determines who gets financing and who doesn't. You follow that?
Well, I think I do, but I still think that is a legal position that any state can adopt for itself, and that this system doesn't appear to make that mandatory on any state. It's just that they won't be able to sell their bonds unless they've adopted. Is that correct?
Practical mandate.
Well, yes, but I don't think, but the Constitution is mostly about legal mandates. It's about when does a state retain or lose its legal right to change its mind about laws. I think if the market forces upon them a uniform set of standards, I don't think that there's a constitutional problem
Even if
with
it
that.
displaces the ability of the governed to participate.
I think that's right.
Okay.
I came here with a question for Anna, actually, on sovereign bankruptcy, but I was distracted by the conversation about right and remedy and also the distinction that it drew between the impairment of contracts and the breach of contracts, which, of course, I'm primarily a commercial law scholar, so the notion that there's a difference between repudiation and breach, which is what's parallel here, is difficult. But let me ask the following question. So it seems like legislation that rejects a contract or that modifies a contract is impairment. But the procedure, procedure that's in place for the collection is something that can be changed. I gather that's the distinction between the collection and legislation. And so my question was really, what about something that's in between? I gather that some states have a legislated process for collecting claims. So for instance, if I supply something to the state and the state hasn't paid and I have a claim against the state, apparently there is an administrative body that Clay, you're nodding, I think hopefully you'll be able to help, that I'll be able to go through to be able to collect my claim. Now that's legislative. So in other words, if there's, I gather that then if there's legislation that changes that process so that it actually extends the time or it changes your right to collect, then that would be an impairment of contract, whereas if, as an executive matter, it were changed, that they decided as an executive matter that the state was going to actually only pay things 5 years after they're due, but they didn't do it by legislation, then that goes to the collection rather than the impairment of contracts.
I don't think it's the legislation versus execution, but
Seeing this the same way, the obligation of contract is either you have to comply with it or you have to pay the damages for not doing that. And I don't think it matters whether it's executive or legislative. I think if it is executive, the way I would analyze that is the executive is always acting pursuant to statute. There's no sort of, the governor doesn't have sort of prerogative powers to violate contracts. He must be exercising some kind of delegated authority under the statute, and I would call that his exercise of that delegated legal authority a law impairing the obligation of contract. The significant, what I think we've been talking about is the relationship between the sovereign immunity and the contracts clause, and there's a tension there because the contracts clause seems to say it's unconstitutional for states to impair the obligation of contracts, and the sovereign immunity says, but even if they do, you can't sue them for money damages. Right? You can sue cities, you can sue proprietary entities, but you can't sue the sovereign state if they have done it. And I mean, I think that's something we've lived with now since the 1790s when the 11th Amendment was passed.
And just to pile on that slightly, that is, I think, in the international context, that's got to be a big part of the explanation for why we haven't seen the collective action problems that have been predicted far and wide, right? We have not seen massive asset grabs and races to the courthouse in cases of sovereigns, even though for foreign sovereigns, immunity is much narrower. But it's just the fact that it takes you 10 years to get $100,000 on a $5 billion, face value has got to be a disincentive to a good chunk of people.
I think you were
Okay. I just have a practical question, not being a lawyer. But and let me tell you what I'm getting out of this, and you tell me if I'm right about this, that there really is so much gray area in terms of what will happen, that there really is no law. That, so that essentially when a state decides to renege on to not pay a bond, they can choose which bondholders not to pay in a way that, as long as it passes the political muster, that's what's going to happen. There's no way there'll be any precedent or any court case that you can pick that will force any kind of discipline on how you choose who to default. Is that a correct assessment? I mean,
unless there's been a waiver of sovereign immunity in the bond contract, which I leave to Clay's informant to but remember, states have to go to the market the next day. Right. I think that this is a matter of market discipline rather than legal discipline.
I don't think there's such a thing as just because Russia was able to borrow 6 months after they defaulted. So the idea that somehow the states are disciplined because they won't be able to borrow again, I think that's just like a fairy tale. If you give up, if you turn around and say, I'm not paying back any bonds, you have a lot of cash right now to use on other things. You don't have to borrow very much at that point. Well, and furthermore, you have a lot of stuff that you could offer as security. So I don't think, I think that,
So, look, I think you're kind of right. So much of this is about politics rather than about formal law. Recall Jonathan's mentioning this morning that during the 1840s, a lot of the investors, because that's where the money was, were from Europe. And there was a lot of the repudiation was about no fear from Europeans. If the bondholders had been domestic residents, I think you would have seen less default. And indeed, what you see during that period of time is bondholders don't get paid, but bondholders aren't the only creditors of states. States are buying on trade credit all the time. They've got employees. They're paying debts. So you're right, they're selecting among which creditors they're going to pay. How would that work out today? Would it work out in a more equitable fashion? I mean, the first conversation I had with David Skeel when he was talking about this was, I said, what's the need for this? States can choose right now with sovereign immunity who to pay and who not to pay. So I think there's something to the to the point you made.
So the question that I would have is, one of the very biggest obligations the states have are to the pension plans. And that's just a huge number, okay? And to the extent that we know how politics works,
Yes.
it seems to me what I'm getting out of this is those pensioners don't have to worry.
No, well, of course they do, because look what the states are doing now. That's just the municipalities. So the Pew Center for the states came out with a report 2 weeks ago that said 31 of the 50 states are below the 80% benchmark for funding their pensions. So if you're asking what are states, municipalities, what debts are they not paying right now? They're not making their pension payments. Now, the pensioners who are going to, right now, are...
No, so I'm looking forward. That's what I'm saying. I'm trying to understand what's going to happen when there comes a time when the states have actually run out of money, because this is all projected things. And it seems to me that it's a political question now. It's not really a legal question.
Yes.
And if it's a political question, the question really is, how big a block and how powerful a block are these people? And
They'll go to the federal government, and they will seek a bailout. And the federal government, as I've suggested, cannot credibly commit in the absence of a constitutional prohibition against bailing out the states. The states will, if your parade of horribles is all the states, the difference between 1842 and now may be, in 1842, the deeply indebted states could not put together a coalition to get the enactment through Congress. If your parade of horribles comes true, and there's enough states in dire straits to create that coalition, then we'll see a federal bailout.
But what about
there is some law in this and not just politics. And don't forget, sovereign immunity applies only in federal courts. These bondholders can go into state court, and that should be a pretty good remedy. And in terms of then the legal aspects, some claimants, you're talking about, so the state doesn't have enough money to pay everything. Some people are in line ahead of others under law, right? And so the bondholders are going to have a security interest in particular streams of money. They're going to be at the front of the line. Pension obligations under most states, I forget the numbers now, but a very large number of states have state constitutional protections for pensions, not, by the way, for health insurance coverage for retirees, which is an entirely different thing. The people who get stiffed first are going to be suppliers and taxpayers who are expecting refunds on their tax returns. They get stiffed almost immediately. The state will start paying its employees in scrip, but whoever has legal priority is going to be able to go into state court and get some kind of a remedy.
No, this is precisely something I asked David about, because priorities are big for him. And his view, for what it's worth, is that they won't, when the push comes to shove, it'll be hard to enforce priorities for the same reasons as it's hard to enforce debts, right? Because the revenues aren't necessarily going into a lockbox, but
Well, I'm speaking only to the surface of the law, whether it,
I was promised that we'll talk about Greek, so I won't talk about Greece. So I actually came back from a conference in London Business School with Moody's, and Mito Gulen was there talking about it, and was describing these 10 contracts that they have and how it's under domestic law, and kind of, again, this mystery of why there's not a restructuring and what is it really about, what's the big secret, and, you know, in ECB or in Germany or somewhere. In any case, my question to you, Anna, is in your pie chart, it wasn't clear where would this Greek debt fit in, because that's not domestically held if it's held in by financial institutions in Europe, or exactly how it fits in, and any thoughts on the Greek mystery?
So Mito and I co-authored part of that, so it's sort of a little cheaty of me to do this. But and I'm sure people don't want to sit here for an hour talking about BIS statistics, which goes to what is domestic debt, right? So the argument by Lee, Buchheit, and Mito Gulati, which they put forward exactly a year ago, saying this is how you would restructure Greek debt in 6 months, goes to domestic law. And the funny thing about Greece is that they are able to issue debt in a currency they do not control under a law they can control, right? To a point, with some remedies at the EU level. I think the overarching sort of law of Greek debt is that it is easier to restructure by far, legally, than any of the jokers on my list. Right? So they can change the law. Yes, there might be consequences, but not nearly as. So why don't they restructure? Not only because of German banks and French insurance companies, but because of Greek banks and Greek pension funds, right? Which brings me to sort of my dominant intuition in all of this, is that what's driving sovereign default management is the identity of the creditors. Partly because of the ambiguity in the legal space. There is law, and I think enforcement bites at the margin. So Argentina has been running around for 10 years and still has not issued internationally. We can talk about why, but I think at that extreme, enforcement bites. But within that space, Greek restructuring a year ago would have just tanked the Greek banking system. And so you're just moving you're moving liabilities from one pocket with a hole to another. What I think should have happened over the past year is they should have figured out a way to recapitalize the banks or put the debt into a vehicle that can eat the losses. And in that sense, I think they've frittered away the year. But this is not a collective action driven delay. And what is offensive about the European response to this is that they're holding up collective action problem as an excuse for something that is patently not that. So that's my 2 cents on Greece.
Great. So, a few questions, actually, one to each of our panelists. Following right on Anant's question for Anna, I wonder if you could complete this SAT-style analogy. I'm sorry to do this to you. So the EU is to Germany, is to Greece, as the US is to blank, is to California. And so the main question is...
North Dakota.
North Dakota, that's what I thought it was. It was North or South Dakota. I wasn't quite sure where they would go. But I guess my main question is, what role is Germany playing vis-a-vis Greece in all of this? Germany exclusively, as opposed to the UK, or as opposed to the broader EU, the governance structure that exists as a matter of law under the Maastricht Treaty, or as a matter of practice as things are playing out? I mean, what is going on here? Is it seen that Germany is the rich uncle who's having to tell the wayward nephew what has to be done, or is there something more complex than that? And then, although I think Clay spoke to this already, it sounds like the fill in the blank, it's just the U.S. is to California, just to say that California, through its senators and representatives, are going to do what they can to orchestrate a federal bailout for themselves. And I wonder if you could talk a little bit about that dynamic. I'm going to toss out a couple other questions just to Clay and Michael, and if there's not time for it, that's totally fine. But Michael, I was curious when Damon was talking earlier about how Abraham Lincoln resolved this question, and that the age of the Articles of Confederation ended not in 1789, but in 1865, and that henceforward we have something of a quasi-federation, and that in this context, there's just no plausibility to the idea that the federal government would ever allow its states to ever default. I wonder what you think as a constitutional law scholar and a constitutional lawyer, what do you make of that dynamic as Damon's described it? And then for Clay, this is, again, you might want to call your friend the bond lawyer on this, but I'm just curious, just on some of the nuts and bolts of how these markets work. We were having this conversation at lunch. First of all, how deep and liquid are these markets? Who are these bondholders? The general idea from others that we've heard is that these are just kind of your mom and pop coupon clippers who want to take something as steady as they come.
No
is there
coupons anymore?
So what does it look like, and is there any capability in these markets for larger institutional investors to come in and generate information out of these markets that might be useful to regulators, other states, other investors to get a sense of, yes, we are approaching something like a problem, and we know that because here's information in these markets. So let's just toss out those questions, whatever you can't get to. That's.
So I can actually answer some of this because we were having our lunch conversation about a similar question, and Google being the world's best research tool, we looked up who are the bondholders, and it turns out that 36% are individual investors. These are September 2010 figures. 36% are mutual funds, which may or may not be a proxy for individual investors. I think it was 10% were banks and 16% were insurance companies.
Do you know anything about where they're located?
Well, what was interesting is of the investors, it turns out, I don't have a percentage, but it turns out that a significant number of them, and an increasing number of them, are foreigners. So that was sort of interesting. But as for generating information, I would think that the best source for generating information would be the insurers of municipal bonds, of which there are still a couple of solvent ones and a couple of insolvent ones. But the insolvent ones may even have more of an incentive to get the information than the solvent ones. So AMBAC, MBIA are still in business, FSA, and Warren Buffett was talking about starting a municipal bond insurance company after the near demise of MBIA and AMBAC during the fiscal crisis. There is a Public Securities Association. Sure, there is already a ton of information out there. S&P may not, they're very good at gathering information. What they do with the information, you may not respect that much. I don't necessarily. But Moody's and S&P that rate these bonds get lots and lots of information about bonds. So the information's out there. There's the reporting requirements. Remember that municipal securities are not subject to the 33 Act, other than the anti-fraud provisions. But there is far more disclosure in the municipal securities industry than there used to be. There is a Municipal Securities Rulemaking Board, which is this very interesting quasi-public, quasi-private entity. So bottom line is there's not a shortage of information about the municipal bond industry. With respect to any given issuer, there may be a shortage of information relative to, say, publicly owned, the debt or equity of publicly owned companies. Yes.
Obviously, people owning those bonds have to have a big stake in tax in the States. Otherwise, they wouldn't buy the bond.
Well, yes and no. So the biggest, if you're an American citizen, you get your big tax break from it being federally tax-free. If you live in New York or in New York City, you get a very big tax break out of being tax-free from state and local income taxes. But for purposes of diversity of your portfolio, and also if you live in other jurisdictions that are not high tax from the state perspective, you might still own municipal bonds, and then you don't care where your municipal bonds are from. in order to get the federal tax exemption. So I think you'll find a concentration within the municipality, within the state, but I think you'll find plenty of out-of-state bondholders, out-of-state residents as bondholders in any given state, as evidenced by the interestingly high, although I don't know exactly how high, percentage of foreign investors or foreign bondholders of tax-free bonds.
Do you have a question for Peter pending? I forgot.
I think Peter had a question for me pending,
Oh.
right? The dot,
Yeah, the
dot,
analogy.
dot. Right, so I'm going to cheat, and I'm going to say the EU is to the ECB, is to Greece, as the US is to the Fed, is to the, but that's sort of just basically saying that all of this is kind of getting washed through central bank programs and can, for a while, I think at some point it has to end up in a fiscal place and you know, get its haircut. But, and Germany, in some ways, I think is sort of a red herring. And, you know, there's just Martin Wolf's line, which is, you know, they let their banks, in fact, you know, sort of, they regulated their banks in such a way that, you know, gave them an incentive to invest in Greek debt. And they didn't spend the past year unwinding that little problem. And so, you know, I'm not sure how much sort of moral ground they have to talk to Greece. And it's interesting that the new ESM, the sort of the European Stability Mechanism, right, is very explicitly, first of all, they say strictly conditional every other word, which sort of is kind of would make you worry, right? Because like if plain conditional is not enough, what are they worried about? And then it's explicitly tied to IMF programs. So, you know, they're trying to kind of hook up to the existing system, in part, I think, because they don't want the fiscal triangle. They don't want this to be a German or an EU fiscal liability, right? So they're framing this rhetorically as more like an IMF-centered restructuring, reorganization, economic program than as a true federal animal. And so that's their political issue.
I'm inclined to think it speaks with a bit too broad a brush to say that Lincoln and Gettysburg are the answer here. I mean, back at the beginning, in the Federalist, James Madison describes the Republic as partly federal and partly national. I think that was accurate then. I think that it becomes more national after the Civil War. I don't think there's any disputing that, but still partly federal. And the national aspect, I would have said, has very little to do with the fiscal structure of the country. The big change wasn't the Civil War. The big change was the 16th Amendment, which gave the federal government such a vastly larger a claim on such a vastly larger share of the national wealth. I don't have the numbers here, but I think if you were to look at the command of resources by the federal government versus the states collectively, that the states overwhelmed the federal government for the first 100 years or so, and probably until sometime well after the 16th Amendment, and maybe even until relatively recent times. There was never a federal a bailout. There was the assumption of debts at the very beginning of the Hamiltonian thing. That was expected. That was sort of not only was it a trade for, you know, for the location of the national capital, but it was understood that that was also a trade for giving the national government the exclusive power to tax imports, plus the VAT, our single largest resource, which is the Western lands, which were going to be sold for this purpose. So I don't know. I guess if I were to have a list of things that have led to greater fiscal integration over time, the Civil War might not be high on my list.
I have a question, which there have been allusions to it all the way along. It's for you.
Okay.
Point of view. We had an allusion to how Russia was back in the market 6 months after its default. You had Argentina up there restructuring more or less continuously through the first decade of this millennium. So So why is that? Is it just this eternal optimism among lenders, or what?
Well, so this is the
I should say,
unfortunate.
I've read that Argentina does it without a significant interest rate hit.
I think Argentina is a weird example now, right? So in 2005, I would have said Argentina is an example of how there is no penalty.
Yes.
As is Ecuador, by the way, which may actually be even more egregious. And Russia, although Felix and I have had a technical argument about that. I think that it's not irrational, right? So most countries pay most of the time, and they pay for reasons that may not be your ordinary reasons. So for example, immediately after the default, investors went into domestic law Argentine debt held by Argentine banks. Why? On the calculus, I think, in part, that Argentina won't wipe out its own banks, and therefore this is a good, so countries' ability to play creditors off against one another, ironically, makes their debt more rather than less attractive sometimes. But I think, also just the returns are high, and Russia, a couple months before default, it took one coupon to pay you off, so why not invest? They were charging effectively 200% interest rates in the summer of 1998. So literally all it took for you was to just get one coupon, so at the extreme.
Thank you all. We have what do we have now? We have a brief recess? No? Or we go straight on? We have a break. We have a break.
So,
Hold on.
when we move through,